This is part 14, and we have started discussing liabilities of the parties with respect to the negotiable instrument. In order to understand this, the chapter to which I had drawn your attention as per the provisions of the Negotiable Instrument Act is chapter 3, and it starts right from section 26 up to section 45A of the Negotiable Instrument Act, out of which right from section 26 up to section 29 are the sections which deal with who can be a party to a negotiable instrument, namely who can be a maker, who can be a drawer, who can be a drawee, who can be a payee, with which you are dealt right from section 26 up to section 29. And then as far as liability of a party with respect to the negotiable instrument is concerned, we started discussing right from section 30 onwards, out of which we dealt with section 30, liability of a drawer. Then we dealt with section 31, liability of drawee of a check. And there we have to make mention of some of the provisions with which we shall be dealing during course of our lecture. But this is the time that I want to draw your attention to section 32, which deals with liability of maker of a note and acceptor of bill. So what is the liability of the maker as far as a promissory note is concerned, and what is the liability of the acceptor as far as bill of exchange is concerned, is dealt as far as section 32 is concerned. And it starts with the wording, in the absence of any contract to the contrary. So there should not be any contract to the contrary. Then we go by what? Then if there is a contract to the contrary, we go as per the provisions of the terms which are laid down as far as the contract is concerned. Otherwise, we go as per the rule that is laid down as far as liability of maker of a note and acceptor of bill is concerned, which is dealt as far as section 32 is concerned. And hence, it starts with the wording, in the absence of any contract to the contrary, the maker of a promissory note and acceptor before maturity of a bill of exchange are bound to pay the amount thereof at maturity according to the apparent tenor of the note or acceptance respectively, and the acceptor of a bill of exchange at or after maturity is bound to pay the amount thereof to the holder on demand. The last part of the section says, in default of such payment as aforesaid, such maker or acceptor is bound to compensate any party to the note or bill for any loss or damage sustained by him and caused by such default. So now this has got reference to what? This last part has got reference to compensation, and yesterday we dealt with section 117 of the Negotiable Instrument Act, which deals with compensation. Now what is the liability of the maker? Maker, in the absence of any contract to the contrary, the maker of a promissory note and the acceptor before maturity of a bill of exchange are bound to pay the amount thereof at maturity. So according to the apparent tenor of the note or acceptance respectively, and the acceptor of a bill of exchange at or after maturity is bound to pay the amount thereof to the holder on demand. So now this is a time where we have to take into consideration the in case of a promissory note, it is the maker who is supposed to carry out payment. When he is supposed to carry out the payment, when the negotiable, namely promissory note, becomes mature. Now as far as the acceptor is concerned, this has got reference to what? This has got a reference to the section 5 of the Negotiable Instrument Act, with which we dealt when we dealt with the definition of bill of exchange. And at the time of dealing with the definition of bill of exchange, we have learned that in case of bill of exchange, there are three parties. One is the drawer, the other is the drawee, and the third is what is known as payee. Now, naturally, you will ask one question, that how is that when we are talking about bill of exchange, it is the acceptor with whom we are dealing. And then in case of a bill of exchange, a direction is given by the drawer to drawee to pay the amount to the payee. And then if drawee, what is required to be done? Payee has to take that bill of exchange to the drawee, and if it is taken to the bill of exchange to the drawee, and if the drawee says accepted, then there starts his liability. So liability of a drawee in case of a bill of exchange starts only when he has accepted the bill of exchange, otherwise not. If you remember, I had drawn your attention to the chapter as far as the acceptance is concerned, with which we shall be dealing right from section 61 up to section 77 of the Negotiable Instrument Act. Yes. But this is a practice. What he will do, payee, or it's not always payee. If a payee can by all means put it into circulation, and then the person, for example, any one of the intermediate party with whom the negotiable instrument is, namely the bill of exchange, will go to the drawee and present it to the drawee for the purpose of acceptance. Now, when he should present, what is the number of hours that are given for the purpose of to the drawee for the purpose of considering whether he is going to accept or not, whether qualified acceptance is acceptance or not, whether there can be a conditional acceptance, all these aspects with which we shall be dealing. But I am trying to simplify by telling that whenever somebody wants to claim amount with respect to the bill of exchange, the first thing that is required to be done on his part is he has to present a bill of exchange to drawee for the purpose of acceptance. And then if the drawee has accepted the bill of exchange, he is what is known as an acceptor, and hence the liability of the maker and then the liability of the acceptor, liability as far as the maker of the promissory note is concerned and liability as far as the acceptor of bill of exchange is concerned is the same. Both are supposed to carry out payment, and hence now this is what is accepted by him. The once drawee has accepted the bill of exchange and who becomes what is known as an acceptor, naturally when the bill becomes mature, as in a case of promissory note, when it becomes mature, it is required to be presented for the purpose of payment. The payee, or if payee has put it into circulation, the one who wants to get amount with respect to the promissory note will go to the maker and ask the maker, please carry out payment with respect to the same. Similarly, once the bill of exchange is accepted, immediately after the bill of exchange has been accepted, the person who wants to claim payment with respect to the same, what he will do? He will go to the acceptor and ask for a payment. And hence now, what is his liability? He has to carry out payment accordingly. And now, if there is a default on a default of such payment as aforesaid, such maker, so there starts liability when there is a default on the part of the maker. Acceptor who is bound to carry out payment with respect to the same is bound in that case to compensate any party to the note or bill for any loss or damage sustained by him and caused by such default. So this is liability of a maker of a note and acceptor of a bill as dealt by section 32, which makes it very clear. In the absence of a contract to the contrary, the maker of a promissory note and the acceptor before maturity of a bill of exchange are bound to pay the amount thereof at maturity. At what point of time both are supposed to carry out payment? But it's in case of bill of exchange, drawee is not supposed to carry out payment unless his liability starts, or unless drawee becomes acceptor, then only his liability starts, otherwise not. So this is as far as section 32 of the Negotiable Instrument Act is concerned. Now with this now, in addition to, if this is the time for me to draw your attention to one more section, and that is section 7 of the Negotiable Instrument Act, which says in case of bill of exchange, you come across one more party. So we have dealt with how many parties? One is the drawer, the other is the drawee, and third is the payee. But here is a party, namely drawee in case of need. And then it says, when in the bill or any endorsement thereon, the name of any person is given in addition to the drawee to be resorted to in case of need, such person is called drawee in case of need. So if the bill of exchange is presented to the drawee for the purpose of acceptance, and then if it doesn't accept the same, if it is dishonored by the drawee, then naturally the person has to present it to the drawee in case of need. So this is a person whose additional name of a person is written in case of need. So when he is to be referred to only in a case when there is a need. And what is the need? Bill of exchange is meant for the purpose of payment. Drawee, there is a refusal on the part of the drawee, and hence if there is a refusal on the part of the drawee to accept, then naturally who will come into picture? Instead of treating that bill of exchange is dishonored and proceeding as per the provisions of the Negotiable Instrument Act for the purpose of taking further steps from the point of view of recovering compensation, then that is required to be presented to the drawee in case of need. And then if it is dishonored by the drawee in case of need, then only it can be treated as that the bill of exchange is dishonored. So there is one more party, what is known as drawee in case of need, as far as bill of exchange is concerned. With this now, if this is a time again for me to refer to, the next part as far as section 7 is concerned, which defines an acceptor, and it says, after the drawee of a bill has signed his assent upon the bill, or if there are more parts thereof than one, upon one of such parts, and delivered the same, or given a notice of such signing to the holder or to some person on his behalf, he is called the acceptor. So what he has done? He has given his the bill has signed. If he has signed his assent upon the bill, then there starts his liability, and he becomes what is known as an acceptor as far as bill of exchange is concerned. With this now, if you come to section 33, it says, only drawee can be acceptor except in need or for honor. And it says, no person except the drawee of a bill of exchange, or all or some of the several drawees, or a person therein named as drawee in case of need, or an acceptor for honor, can bind himself by an acceptance. So who is liable, or who is liable as far as the bill of exchange is concerned? It says, no person except the drawee of a bill of exchange, or of all or some of several drawees, or a person named therein as a drawee in case of need, or an acceptor for honor, can bind himself by an acceptance. So this is, who can become an acceptor, or who is bound as far as the bill of exchange is concerned, is made very clear as far as section 33 is concerned. Now section 34 deals with acceptance by several drawees, not partners. And then this section, it says, where there are several drawees of a bill of exchange, that we have learned that role of a drawee can be played by many, namely there can be many drawees. So now it says where there are several drawees of a bill of exchange who are not partners. So they are not at all partners. There are several drawees. The direction is given to number 1, maybe number 2, or may call him Mr. A, Mr. B, Mr. C, Mr. D are different drawees. So the direction is given by the drawer to them to pay the amount. So when there are several drawees of a bill of exchange who are not partner, each of them can accept it for himself. So what is the law? It says each of them can accept for himself, but none of them can accept it for another without his authority. So if it is accepted by Mr. A, who is one of the drawees, then he is liable. So he cannot, but none of them can accept it for another without his authority. So unless there is authority which is given by other drawees, so there are several drawees, as section makes it clear. When there are several drawees of a bill of exchange who are not partner, each of them can accept it for himself, but none of them can accept it for another without his authority. So that is the procedure which is required to be followed. And then who is liable when there are several drawees? One who has accepted, each of them can accept it. It can be accepted by each one of them for himself, but none of them can accept it for another without his authority. So this is as far as section 34 is concerned. Now, as this is a time for us to proceed further. Though we are dealing with a chapter right from section 26 up to section 45A, there are some sections to which we have dealt in the past when we were discussing endorsement, and there we dealt with endorser is also a party. But what is liability of endorser? For that we dealt, if you remember, with section 35. Now section 36, so liability of endorser, with which you have dealt as far as section 35 is concerned. Liability of prior parties to a holder in due course, with which you have dealt as far as section 36 is concerned. It says every prior party to a negotiable instrument is liable thereon to a holder in due course. Now this has got reference to what? When we were discussing what are the rights and privileges of a holder in due course, there we learned holder in due course has got right to recover amount from any one of the prior parties, and that is exactly as far as section 36 is concerned, which says every prior party to a negotiable instrument is liable thereon to a holder in due course until the instrument is duly satisfied, namely until the payment is carried out with respect to the same. With this now, we come to section 37, which deals with maker, drawer and acceptor principles. And what it says, the maker of a promissory note or check, the drawer of a bill of exchange until acceptance, and the acceptor are, in the absence of contract to the contrary, respectively liable thereon as principal debtors, and other parties thereto are liable thereon as sureties for the maker, drawer or acceptor, as the case may be. This is the time for you to refer to section 126 of the of the Indian Contract Act for the purpose of understanding contract of guarantee. A contract of guarantee is a contract to perform the promise or discharge the liability in case when there is default on the part of the person. So this is a contract of guarantee, is a contract to perform the promise or discharge the liability in case of default of the person. Namely, default of whom? So in case of contract of guarantee, there are three parties. One is the creditor, second is the principal debtor. From the point of view of understanding this part of the Negotiable Instrument Act, and third is the surety. So what is the undertaking that is given? Undertaking that is given by the surety is that in case there is default on the part of the principal debtor, I shall be liable, I shall be paying the same, or he takes the responsibility in case when there is a default on the part of the principal debtor. So now the maker of a promissory note or check, the drawer of a bill of exchange until acceptance, and so how long the drawer is liable in the capacity of maker? Yes, the maker of a promissory note or the drawer of a check, yes, but they are principal debtors. But the drawer of a bill of exchange until acceptance, because once it is accepted, it is the acceptor who becomes a principal debtor. And it says the acceptor. So once it has been accepted, the acceptor, or in the absence of contract to the contrary, in the absence of, as usual, when there is no contract to the contrary, respectively liable thereon as principal debtor. So they are supposed to carry out payment. And if the payment is not carried out by them, and the other parties, those other parties are liable thereon as sureties. So if the amount is not paid, by the maker of the promissory note, if the amount is not paid by the drawer of say acceptor, in that case, for example, then only then only the other parties thereto are liable thereon as sureties for the maker, drawer, or acceptor, as the case may be. So rest of the parties are sureties. This can be understood by you if you refer to section 38. We will have clarity. And what section 38 says? It says, as between the parties so liable as sureties, each party is, in the absence of a contract to the contrary, also liable thereon as a principal debtor in respect of each subsequent party. And there, this is a time for you to take into consideration illustration where A draws a negotiable instrument in favor of B, who is a payee. Yes, he is a payee. He puts it into circulation, irrespective of the nature, whether it is a promissory note, whether it is a bill of exchange. He puts it into circulation. From whom? From B to Mr. C, from C to Mr. D, from D to Mr. E, and E to Mr. F, and F to Mr. G, as he has negotiated the negotiable instrument, and now it is with Mr. G. Now, in order to understand what is, right of Mr. G, G has got right to recover that amount from any one of the prior parties. If that amount is recovered by Mr. G, of course, who is the principal debtor? The principal debtor in case of a promissory note, yes, it is the maker of the promissory note. In case of a bill of exchange, the drawer, but if once it is accepted, acceptor becomes, so he becomes a principal debtor. And if it is not carried out, payment is not carried out by the person, namely if it is not paid, if it is not honored by the person who is supposed to carry out payment, naturally the person who is having a negotiable instrument which is dishonored has got right to recover that amount from prior party. So now if Mr. G has recovered it from Mr. F, then naturally Mr. F has got right to recover from any one of the prior party. So if he has recovered it from Mr. E, E will recover it from Mr. D, and ultimately the party who is supposed to carry out payment, if it is recovered from that party, then it is satisfied. So what is when we talk about when we talk about Mr. D, who is the intermediate party, and what it says, Mr. D has got right to recover from amount from prior parties, whereas Mr. D is liable to the subsequent parties. And this is exactly made very clear as far as section 38 is concerned. It says, as between the parties so liable as sureties. So these are all, I mean, surety. That is, if the amount is not paid by the principal debtor, namely the person who is supposed to carry out payment or who undertakes, and this is I mean, this is very clear. This is very clear that he undertakes to pay the amount. If it is not paid, if it is dishonored, then only, I mean, he has got right. The party who wants to recover the amount can recover amount from surety. You have to proceed first of all against the principal debtor accordingly. This principle can be very clear, as I mean, if you refresh your memory, right from section 124 onwards, as far as the Indian Contract Act is concerned. 124 and 125 are the sections which deal with contract of indemnity, whereas if you start right from section 126 onwards, this is a contract of guarantee. And in case of contract of guarantee, when there is failure, default on the part of the principal debtor, then the creditor has got right to proceed against the surety accordingly. So this is the relationship between the principal debtor and the surety and the creditor as far as the provisions are concerned, to which the mention is made as far as this particular chapter, particular section is concerned. Now with this, now we have to, I mean, deal with one more section, and that is section 39, which deals with suretyship. And what it says: when the holder of an accepted bill of exchange enters into any contract with the acceptor, which under section 134 and 135 of the Indian Contract Act would discharge the other parties, the holder may expressly reserve his right to charge the other parties, and in such a case they are not discharged. When the parties are discharged from liability is the chapter with which we shall be dealing, or when the parties who are liable with respect to the negotiable instrument are discharged. And what we shall do, when we shall be dealing right from section 82 of the negotiable instrument act up to right from section 82 up to section 90. This is a chapter, and if you refer to this chapter right from section 82 up to section 90, deals with what? Chapter 7 deals with discharge from liability on notes, bills and checks. So when the parties are discharged from liability as far as the promissory note is concerned, bill of exchange and check is concerned, with which we shall be dealing, that is one chapter with which we shall be dealing. And then we will have reference to what? We will have reference to this section, namely section 39, from the point of view of understanding it very clearly. With this, we dealt with section 40, discharge of endorser's liability. So this is what is the when endorser. This is also, I mean, we will refer to this, but we have already dealt with this at the time of discussing endorser, that we had taken into consideration. With this, now there are some other more provisions as far as this chapter is concerned, with which we will continue our discussion as far as next part of our lecture is concerned.